you know, and then the last. Yes. Yeah? No, you're right on time today. You're right on time.
Nani? Here with him. Sini watu wasomesongesha tu, mimi ndio naseti na hapa na wewe.
Sasa mwingine anapita kitu kanaweka nini katikati.
Sasa tutakuwa sauti. Shika hii.
Chukua vitu vyenye unataka tupe bali ndani.
Yes. Unasiita ndio hivyo ndio tu.
Toa mwili.
Akisimalize guy.
Tuweke side gani?
Kwa shoti yangu.
Wewe?
Panga alafu ukae hapo.
Waulize tukipanga.
Naomba.
Anavuta.
Number is 24 of 2025, Republic versus George Natembeya.
Present, Your Honor.
A minute. The last name? Mugambi, but Mulambi. Oh, Mulagi, yes.
We have Simon Wuro. I'm present. We have Willie Sokino. We have Asha Bashir. Zan Alakona. Edgar Busieba. I'm sure he should be this way. Then Kibe Mungai. I should also wish to have it written on record. The senior counsel, Honorable Alonso Busioka, will also be joining. And senior counsel, Honorable Mother Karua. Provisions to purge Ken Ichesa.
I'm present, Your Honor.
Walubengo Waningilo.
Present, Your Honor. So, the last name?
Walubengo Waningilo.
Spell for me, kindly.
WANINGILO. And finally, Mr. Obuli.
That is Mr.
Obuli.
Appearance of the second accused.
As you know, the matter is coming up for plea. We are ready for plea. We shall find ourselves. And even sir.
Atajipanga bwana.
Your Honor, we just been served with charge sheet now. We just move on.
Sindiro, you ready for plea?
We are ready.
You have issues, but you ready? Somebody, you have not commented about the second accused.
One comment raised wrong that we will pray for someone for the second accused. We deal with that later.
Proceed.
Judge Natembeya, which language do you understand? English or Swahili? Which language do you prefer?
Mic is not working.
Count number 1 against accused number 1. Conflict of interest contrary to section 42(3) as read with section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense being George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to which the governor of the county government of Trans Nzoia you knowingly acquired an indirectly pecuniary interest in the sums of Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, which traded with the county government of Trans Nzoia. Is it true or not true?
Not true.
Count number 2, conflict of interest contrary to section 42(3) as read in section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense: George George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to the Governor of County Government of Trans Nzoia, you knowingly acquired an indirectly pecuniary interest of the sum of Kenya shillings 2,124,668 from Emmanuel Wafula Masungo, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true? Count number 4. Unlawful acquisition of public property contrary to section 45(1)(a) as read in section 48 of the Anti-Corruption and Economic Crimes Act of 2003, particulars being you George Natembeya between 1st January 2025 and 30th April 2025 within the Republic of Kenya, being the Governor of Trans Nzoia County Government, you unlawfully acquired public property to wit Kenya shillings 3,252,568, being part of the payment made by public government of Trans Nzoia to Lima Agro Science Limited, Maira Stores and Easterly Wings Limited in conflict of your public interest. Is it true or not true?
Your Honor, these are the simple charges in the case of we are actually shocked to see that we've been served in an affidavit by the prosecution to purport to impose bail. The directions you need to give us is whether you wish the prosecution to go fast, we will respond to it because you would have expected the narrative that the accused person should have been released on bail, actually free bail, so to speak. But we have an affidavit that is up on us now to be charged. Even if I may, my name is Awiti. We have instructions for post-pay, instructions from our client, the Director of Public Prosecutions. And as regards Mr. Nyeru's request for directions, we believe that because we are post-pay, and bail being ordinarily a right, then it has to go first in an application to post-pay. They'll have a chance to respond to our application. That's a way we can go upon our arguments. My learned senior, Mr. Akula, will take the court through the affidavit, the functional matrix. Allow me to take the court through the legal matrix. Now, I'll start by indicating that the law on bail is almost settled. Sorry, Your Honor. All right. My apologies. My apologies. I come from the lakeside. I speak. Your Honor, our application in Thank you, Your Honor. Like I was indicating, the law on bail and bond in Kenya is settled, or almost settled, if not settled. And and our arguments are founded on Article 59(1)(h) of the Constitution, Article 50, there, sections
159,
sorry, Article 49(1)(h)
49, 1,
of the Constitution,
50,
50, thereof, section 123 and 123 capital A of the Criminal Procedure Code, and of course, section 8 of the Magistrates Court Act, which gives this court the jurisdiction to entertain this matter this morning. You know, it is the import of Article 49(1)(h) that bail is a constitutional right, and that every arrested person or an accused person has an entitlement to bail unless there are compelling reasons to deny bail. Now, we submit to you, and we believe that at the tail end of our submissions on the prosecution side, we shall have established at least 3 compelling reasons, at least 3, there could be more, to justify this court's denial of bail for the accused person before you. And Your Honor, just to emphasize, the import of Article 59(1)(h) is that while bail is a constitutional right which should ordinarily be granted, where such compelling reasons are established, the court must deny bail. You know, that you do not have a discretion. Where we establish compelling reasons, you cannot exercise any discretion. You must deny bail. And Your Honor, just on the question, so, Your Honor, unfortunately, I'm not able to read the court's pen. I'm short as well. But the court could guide me when I'm able to proceed. I appreciate that.
every sentence closed.
Thank you.
And your Honor,
Yes. Your Honor, that further on the question of discretion, the discretion that the court has on the question of bail then arises where the court has dismissed all the compelling reasons and is to set terms and conditions of bail. That therefore, Your Honor, where there are compelling reasons, as is our submission, then the court cannot grant bail, and therefore the court does not have to get to the discretion of setting terms or conditions of bail. You know, because I have had the benefit of appearing in the number of counsel for the defense in this matter, I can preempt what they are likely to tell you. that the right to bail is also, I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give them a chance to state what they are.
I am allowed to preempt and give
The
arguments.
defense has the capacity, Your Honor, and we will not want the council to belabor, to just speak for the state which it
A minute,
represents.
a minute.
The accused has sufficient
A
defense.
minute. Decorum. Decorum. I repeat for the third time. Decorum. Mr. Witty, I give directions. Give the defense time to state what they have to state. State what you have to state.
That's right. There is the question of the relationship between the right to bail and the presumption of innocence. It is straight law.
Pause.
Oh. It is straight law that the denial of bail, where there are compelling reasons, is not a breach of the presumption of innocence. I trust the court to have a look at the Chomley case. I'm not very good with spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice there, the Chomley case is clear on the relationship between the right to bail and sorry?
At the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 there, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right of presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of rights under Article 24 of the Constitution. whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines. Judiciary Bail and Bond Policy Guidelines, together with 7 decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an accused person shall be present for trial. But there is the secondary corollary purpose of bond, which is to protect the integrity of the trial before you. Protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, we are releasing an accused person on bail will prejudice the integrity of the trial. We are releasing an accused person on bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. A likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on section 8, subsection 2 of the Magistrates Court Act. Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. Now, that jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Kulu.
Sworn on 19th May 2025 by Mr. Robert Sworn. 19th of May 2025, this month. Yesterday, trial this morning. Yes, it is sworn by Robert Sworn. Robert Sworn. And ECC forensic historian. There are the factual reasons or grounds to take bail are therefore in paragraph 1, paragraph 2, however. I will cluster them into three, 1 to paragraph 12. However, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person who is agents, the accused person who is agents attacked EACC and LPS officers in lawful exercise of their duties. Now this has been reported and is captured under annexure RR38. Kitale Police Station. R38. PR38. And extra PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection now is founded on section 106B of the Evidence Act.
That is your name.
Who is the counsel for the first accused. Section 106.
Based on
Section 106B
on electronic evidence.
for electronic evidence.
You get it time.
No, I'm not raising an objection because it's highly required to use.
You get your time, get it.
Possible. We have a next.
I want to confuse the direction.
We have next a series of photographs marked as RR1 to RR37.
1, 2, R.
37. Your Honor, those photographs depict vehicles belonging to ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing one of the unit.
Executing.
Their lawful mandate. That is, doing a search pursuant to this Minister application E716 of 2025.
Come again. This thing has application number
E716
E716.
of 2025. That is detailed in paragraph number 4. Now, photographs RR3 to RR10. RR3 to RR10. They depict the motor vehicle KCH 046T.
Come again. 0.
46T. After it had been balanced. There are photographs R11 and 12. Depict KCD 628X. After the balanced. 541. And photographs for RR14 to RR26, the motor vehicle KCF, (541) U, KCF 541 U. Then at paragraph 7 and paragraph 8, the officer depots, paragraph 7 and paragraph 8, Mr. Ronald depots that after vandalizing these vehicles, important documents were taken. Now we take judicial notice of the position of the first cause. The witnesses in this case, Your Honor, upon disclosure, are his subordinates, people employed under his government. Now, what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is with the witnesses.
The test is
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, and I'm aware of the directions you have given about the temper. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are subordinates of the government.
give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one suit.
I want to
But let me record you first. Mr. Kula, give me some time. I need to record this projection.
submitting that once disclosure is done, the witnesses will be calling officers from the first case study. Those are disciplinary. I'll take the second link, severity of the offense. I got the second compelling reason. When appraisal of the child, the amounts will appear caution.
The amounts will appear
Minimum. 1 million. I should believe Your Honor will win this case. And will draw your attention to section 62, 1. Over 7. 62, 1 over 7. In the event we succeed, that provision is very critical.
in the event.
We succeed.
We is the
DPP
DPP.
prosecutes this case. We get conviction.
This success.
Yes. We will be moving to section 62, subsection 1. And on that, the severity of corruption cases. Will it be a recipe for someone to interfere? We submit to the positive. Lastly, public safety. I've alluded, Your Honor, to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice process, that our applications now, and at least for the court to have an independent opinion, a plea bail report be available. A plea bail report be available before this court and decide on this. Thank you.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank you.
How many of you would like to lead this way? I'll take it because I listed how listed 11. Yes, and one number of us. So how many? Just to manage our expectations.
Because the issues are straightforward, Your Honor. Okay, let me start by introducing Senior Counsel John Greenwan. He's our client.
Then I will do it. I will do this also, yeah? So that is arraigned. Let me be the first one to just give some. Let me on the outset state that the prosecution is posing the necessary ground in an otherwise straightforward manner. And our focus at this point will be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes. So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel who has now practiced for 33 years, I get concerned for how long is 33 years?
That is not for intimidation.
When we
But I'm sure Dr. Hamino is smiling at you.
actually it's a sign.
Very sad.
Your Honor, when prosecution purports to teach this court the law, citing authority, citing sections, pointed out to deny an accused person bail, these are things that before I stand here and pass about, I'm certain that the
sorry, Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice. We plead that senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us. Thank you.
Mr. General, to record the objection.
There is a special reason, Mr. Njero, I did what I did to your side, so that we remain focused. So remain in that trajectory. Absolutely.
My plea is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now is used to harass opponents. That's wrong, and we shouldn't allow it. Your Honor, I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been in private practice. One of the few. And I know how things operate in those agencies. I was the first year of independent police oversight authority, and we had a lot of run-ins in the executive. Constant interference, attempts to direct us on how to do our work, including by the current president when he was deputy president. And this is factual. It's in public domain, it is known.
Mr. Njero,
I'll give the context. I'll give the context. Yes, I'll give the context.
Focus here, Mr. Njero, a minute.
I'll give the context.
A minute, Mr. Njero. The focus here is the accused, the law, the constitution. understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in, but I can swim in the Constitution, I can swim in the law, I can swim. That's why I can swim in submissions around those things.
The reason why I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as somebody who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few money to do that. That is the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner. We understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit. Yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit recently. What time do they expect us to respond to that affidavit? You know what is the truth? That it is designed in a manner that will expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tweets. Then the affidavit itself is marred with general averments. This is factual. They are talking about respondents, agents. They are not naming which agents.
So just to be clear, you responding to the objection or you continued with your submission?
I'm responding
That I'm clear.
He cannot say that I'm making general averments. Yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back. In the very least, that should be expected. He can't have a steak and eat it. In fact, we should be given more latitude because the subject of these proceedings is the accused person. The rest of us are sleeping here, and then we walk away. But this is the subject. That is the person we should focus on.
Give me time to give direction.
accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including the very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. Besides being a governor, elected governor of a county. What was so difficult was just someone to court, telling me to appear in court in such and such a way. Why all the drama? Arresting the man and putting him in custody for this kind of challenge. It can only be for the sole purpose of punishing him. It can't be anything else. And it is that desire to continue punishing him that is driving the application for him to be denied freedom. You cannot allow yourself to in realizing that objective. You can't. I have consistently seen the last line of defense of this country. The only one remaining, Your Honor, is the judiciary. And if judges and judicial officers allow rights of accused persons to be taken away, we have no country. None whatsoever. And let's not think that when you allow that trajectory, that anyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these constructed submissions and responses and counter-submissions, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to be meted in this custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court, and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged dysfunction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Kitale. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawful use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give the last aspect. Honor, just to associate myself with the submissions made by Milimani Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is
Slower. Pause after every sentence.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When we sought for explanation, Your Honor, Milimani Senior indicated that he was seeking summons. It's the same mischief, Your Honor. When you sought for clarification from the prosecution, the opposition, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny bail must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODPP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Passing to the elections, to directed the focus on the charge sheet. If council has any pass on the elections.
Minute and recording is start.
The direction.
Minute, I'll give you directions.
The directed will focus on the charge sheet and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will read it to you. So let him speak on bail. The rest of this person. We just don't feel any motive to anybody unless they are willing to take the law and willing to proceed.
Your response, Mr. Njiru.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I also proceed in response to the substantive application,
Must be direction and the objection. I remind that once more, I belong to the law and bond and bail. Avoid instances which may persuade me to request the fact having evidence from your end.
I am well.
Which will render you in a very awkward position.
I am well. Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
After every sentence, you have to
And there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmants in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here that the intended witnesses are subordinates to the governor, the accused person, again is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, Your Honor, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. The same is not empirical, and there is no nexus between that affirmation with the affidavit and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more annoying, is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. You know, the producer of the so-called annexures, for instance, will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 798F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. Permit me just to, as a pen-off, and invite my other friends to draw your attention to the charge once again, that there is no charge that the government is facing that is linked to his office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of a charge, in the absence of evidence, the argument and the averments by the prosecution is not to be believed. I was perplexed, Your Honor, in summary, when I heard my young friend Mr. JV invite
about
in isolation about 25.
Leo tumetembelea kanisa Apostle Ng'ang'a.
Invited you to the only jurisdiction you have in that respect relates only to section Article 25A and B. Curiously enough, and in the attempt to persuade you, he delinks the presumption of innocence and a fair trial from Article 25. He tells you that the Your Honor, that the presumption of innocence.
I need to stop.
So people like us. He tells you that the right of presumption of innocence and Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defiling our Constitution. Family, you know, what is compelling? If you look at the law, Black Laws Dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such affirmance has been pleaded. No evidence produced. No law quoted. No case law referred to. And as such, Your Honor, the granting of bail to our client will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations. And Your Honor, be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Jero to guide us on who next. Thank you very much.
Now I'm worried. How long more?
We won't take more than 10 minutes.
10 minutes. I also give you a case law.
So how long are you?
10 minutes.
10 minutes.
Another
non-extent?
This Swedish? They'll be very brief. We have 4 more, but they'll be very brief. I'll manage the situation.
Always remember, the court has also business. So we submit here the whole day. We understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is enough. Absolutely. You don't need to give 100 sentences in circumstances where you can give 1 sentence. I think that broad guidance serves us right?
Yes.
So we don't need to talk, all of us. In fact, I expected Mr. Njeri to ground this. There is no need of all of us.
We will be very brief.
We are guided.
So this is Mr. Chesa. Chesa, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives you authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused by literally breaking into the accused person's residence in Kitale at Nairobi, bundling into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Johnson Mgunya and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term there is cogent evidence and not mere allegations. You have been told through the affidavit of Mr. Rono, he keeps referring to some ghost creatures called agents of the respondent. Agents of the respondent attacked ESCC vehicles. Agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Trans-Nzoia County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for med escape. Jero. Jero was asked for clearance for med escape to access his client. At what stage the governor plan with the so-called agents to do the unimaginable things that the state is supporting? Your Honor, in Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor. 2 more minutes, if this court allows. But just have 2 case laws and we can do that 1 case law.
If we can stick to directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5.
Just one
I
more.
closed my eye to say you're finishing on the 6th minute.
Okay, just one more. In that case, you recorded that the seriousness of the offense.
I repeat, one word is enough.
Lastly,
I don't know why we get this temptation that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
Yes.
Sometimes it is counterproductive.
This last one, R versus Richard David Alden. R versus Richard David Alden. David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
Second case. Just list that. I will look at that.
Very well. I think that was the last case, and the person must demonstrate actual witness interference, not mere allegations. Witness interference. Employees of the county government are retained by county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simiyu was the accused person in the ACC. We only say on the follow your guidance. Mr. Simiyu. Your Honor, take 2 minutes. And I'm addressing
Proceed, Mr. Simiyu.
Thank you, Your Honor. Your Honor, number one, I just want to write on what Mr. Chester has said. The accused person did not have capacity to direct. Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. You need your 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed as at 6:30 a.m. yesterday,
the accused person had lost his 2 phones. And of course he was in custody. So he could not speak to third parties. So, Your Honor, the averment in the affidavit by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accuse persons Kitale Milimani residents. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. 1 is Rongai residence in Nairobi. 2 is a residence in a place called Kibomet.
Come again.
First is
Second.
second is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused person's home are genuine. And Your Honor, to cut that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to Sompek. You read it reason.
I yield.
Honest to records.
Thank you.
No, I'll try 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop then.
Yeah.
The first point, Your Honor, is just to raise a point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Honor, Section 106, Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Let me remind you. The applications contain the
in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court, not a warden of the state. Bail and bond for pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it.
Mr. Jerry, your last soldier. Is it your last one?
Listen and then they are talking about Amino.
Dr. Amino.
Thank you, Your Honor. I'll take only 2 minutes.
Just like you said you were taking 2 minutes.
2.5 minutes. Your Honor, I'm very glad to appear before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in the maiden opening, and you are the first that I'm appearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Smio. I think he taught me very well, and that's why I've been proceeding on. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'll not go into that issue because my senior counsels before me have already spoken about that. how do we look into the classification of what the state has alleged? Classification. Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a cold floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, at least let the court make me understand, whether the arresting officer is the investigating officer and the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, you sure you want that to go to record?
I think it should, because I can substantiate it. Your Honor, what I mean by literacy is not literally academic, schooling, but experience. And if we are to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
You've admitted yourself.
Thank you.
Daktari, how long? I'm not even sure whether it will fix time for you.
I will be extremely brief,
Very well.
except I'm asking for one indulgence.
Yes.
I have my own friend, Mr. Dubi. I always appear with him in the cases. He has only one word that he wants to tell you. Only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, please look at the charge sheet. Point 1, the persons named there are 2. The particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is for governor or the president for governor. The second point related to that is particulars in the charge sheet under the law, and I take it to be something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was speaking this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the brother. And the third count relates to the manual we're going to talk about. Last, and this is about the allegation of planning cars and government. Something I was told when I was being talked to the grandparents. much younger. We were told monkey see, monkey do. When the government itself lets court orders, citizens have no reason to monkey see, monkey do. When government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything helpful. So the citizens are taking after the character of the government. And very lastly, I do recall off the top of my head, the governor of Istanbul, who was charged with the blood of some point. The court ordered that he should not go to the county government. So this issue of interference with subordinates, if there are any, but my colleague just every does not say the court has authority and discretion to give conditions that will ensure that the proceedings of this court are upheld in effect.
Thank you very much. Your Honor, I was very, the first point I would like to make to you, respectfully, Your Honor, is that several councils or advocates have spoken. They have made submissions. I would respectfully ask that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a written ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reason to better.
Yes.
Has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I ask you very respectfully that before you rise this morning, you make an order that the governor is released, court, and you deliver the ruling later. I also urge you very, very respectfully, Your Honor, that we will not free fall. The governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation. And there's no way he can leave Kenya for another country. Give him a free fall. And you will also be educating certain people and certain people that the criminal law of the country must not be abused at all.
Slower, Dr. Slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored. And it's okay.
That the governor is released on a free bond and you will give your reasons much later. Your Honor, permit me to continue.
Continue.
Your Honor, I'm a child born in the colonial days.
You're a child of?
Born in the colonial days.
Colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature, of sociology, anthropology, philosophy, when we had terms like the African mind, how the African thinks, and so on, from the colonial. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was
statement is home, Daktari. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the petition. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Sun, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
Your Honor?
That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do. Then we can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can someone give me the judge? Your Honor, the judge you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not being told that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Camino